Senator, I want to thank you for bringing this forward. We've gone through this before, unfortunately not very successfully. And it's interesting listening to the opposition, because what the case that they really want to make is that the consumer protection laws are there to compensate for injury, which means that they're not a deterrent and they're not preventative of injuries. That is just inhumane.
Yes.
And just
Yes.
an astonishing interpretation of the body of consumer protection law. And what your bill really does is sunshine defects so that they can be dealt with, not in 10 years, 15 years, 20 years while people get injured, but get dealt with immediately, because consumers are then informed
Yes.
of the danger and can make informed choices when they're in their market. We are a market-based system. It's also interesting, the opposition seems to kind of gloss over the fact that much of the consumer protection laws in California are common law. They're judge-made laws. So I think the courts know how to handle definitions, know how to handle and interpret what we do and from this committee standpoint, the way that you've crafted this law, I think, meets an appropriate standard for how courts then could adjudicate what is before them and deal with confidential information. And it's just astonishing to me to think of defects and environmental hazards being considered trade secrets. None of the companies I have ever worked for would have considered such as trade secrets, but yet in this context, the whole current way that the opposition want to construct the consumer protection law would mean that defects are part of someone's trade secrets. That is kind of astonishing to me. So I appreciate the effort here, and I wish you the best.